Welcome back, and thank you for staying with Morning Express. We're definitely looking at various matters that touch on your day-to-day life. This time round, we focus on the newsroom, and it's all about copyright laws. I mean, we remember the Jerusalem Dance Challenge. It created a feel-good sense in the community. Various people, institutions, organizations did jump on this dance challenge, but it was not all smiles when Warner Music came demanding license fees for using that particular song. So, can we use some songs in promoting ourselves? How far can we go with it? We try to understand these particular issues surrounding copyright laws, rather. And I'm joined in studio by Faith Amatika, who's a senior legal counsel with the Kenya Copyrights Board. Thank you so much for your time. And also joined via way of Zoom, Liz Lenjo, who's an entertainment lawyer and is joining us from Kilifi. Ladies, thank you so much for your time. Welcome to the broadcast. I'd like to begin on this particular note. I mean, I don't know if you did the Jerusalem Dance Challenge. I did. Luckily, I didn't post it. Would I have gotten into trouble if I did post it? Let's start with you, Faith Amatika. What guidelines are there?
Thank you. Thank you for having me in studio today. Well, the thing with copyright is that copyright is a right that a copyright holder, that is an author or basically, let me use the term author, the right they have to their work, be it music, be it a book, be it a movie, be it whatever it is. So when people posted the Jerusalem dance on YouTube or on other platforms, it amounted to what is known as reproduction, and that is usually a preserve of the author. So, you know, posting and reposting and sharing and resharing usually it could amount to an infringement of copyright if the author's permission is not sought. So yes, it could have been an infringement. Okay,
well, this is interesting. Liz Lenjo, we live in times where social media is definitely at the center stage. I mean, TikTok, Instagram, these videos are definitely catchy and they trend. So how exactly might I approach this current trend, but bearing in mind reproduction might be an infringement? Talk to us about this.
Okay, so with copyrights come exceptions to copyright, and one of the exceptions that we have is private use, that you get to enjoy some of these works in the confines of your personal space. The digital space has now revolutionized that. So, you know, there's that lack of understanding or interpretation on to what extent is personal space in the digital era or in the digital space as well. So remember now when you put, you know, all this content now on your Facebook, on your TikTok, you now have, you know, sort of crossed over to that right, exclusive right that the author has of, you know, reproduction, of distribution. Again, as Faith said, it's a preserve of the author, because what copyright gives is the right to control. How do you control the property that you have created under copyright? In the digital space now, things change. You know, now we're talking about reproduction, we're talking about distributing, which is something that should be enjoyed by the author. So then you have to be very careful. Again, you know, permission of the author is important, because you have to talk to the author and tell them, this is what I want to do for with your work. This is how I want to use it. Is it okay with you? If it's free, then it should be in writing. If you're paying a fee as well, it should be in writing, because again, you know, when we're dealing with copyright works, and you know, a license, a written contract has to be in place. So which means, again, you know, once you put it in the digital space, you know, the conversation about personal use will change. And in this instance, now what we saw with Jerusalem is, you know, corporates got excited, you know, entities got excited, and they were like, oh my gosh, we can use this dance and people will see us, our brand will be visible. And of course that changed things. So okay. In this instance, you know, permission was necessary.
Okay, so Faith Amatika, if I wanted to use it personally, I might not need to seek permission, but if I needed to use it in terms of advertising or promoting an institution or organization, this is when I need to approach the owner of the song and ask for permission, right?
Yes, yeah, because when you use it for your own personal use, like you just use it at home, you entertain yourself at home or in your own small birthday party at home, then you really don't need permission, because that is just your personal private use. But if you use it in a commercial setting where you promote your business, like we've seen with the issue of Jerusalem, where brands and corporates used it to gain popularity, because once somebody hears the Jerusalem song, they will be keen to look at this company, like what is it doing? And then they end up advertising themselves. So they gain some advantage from that song. So that is wrong. And that is why now Warner is coming in and saying that they're going to be issuing invoices to those corporates.
Okay.
So, yeah.
But there's so many viral challenges right now, Liz Lenjo. I mean, wouldn't I have the moral ground to stand and perhaps accuse Warner of trying to jump on this viral challenge and its good intentions and trying to fill their pockets through this particular means? Talk to us, because this is the digital space. We also have an emergence of yet another song called Firirinda. I don't know if you've heard about it. Many people are doing videos about it. So what lines shouldn't we cross?
So, I'll ask, the audience, if you have a piece of shamba, a piece of land, and, someone wanted to use it, shouldn't they ask for your permission? Copyright, intellectual property rights are proprietary rights, which means the author has the right to control and decide what they should do with them. So in this instance, you cannot claim that someone is being petty or, that, they're being unfair, because it's their work. It's their right to control how it will be used. And I think it's about time that we realize that these rights have proprietary rights. It's in our Constitution, it's in our Copyright Act, it's in our various, intellectual property statutes, that at the end of the day, the creations of the mind are equal to property, right? So it is important that we respect that, and then we realize how we can navigate that space for the benefit of the author and for our benefit. So we have to be fair. I think we're still learning and understanding what copyright is, especially as an entertainment industry. And the digital space is making things more interesting and creating very interesting challenges that now require for the law to be interpreted further, perhaps. But I would say that at the end of the day, you have to respect the author's rights.
Okay.
It's simple as that.
Okay, Faith Amatika, talk to us a little bit more about intellectual property rights, because this touches on the legal rights of the authors of this particular song.
Okay, well, intellectual property rights are broad. They're quite broad, and copyright is just one of them. So our intellectual property rights encompass, what we call patents, what we call trademarks, design rights, and all that. But now when we talk about copyright, this is now what protects creative works, where we talk now about music, we talk about movies, we talk about books, computer programs, and things like those. So basically, as my colleague Liz has said, these are rights that are they're actually enshrined in our Constitution. Article 11, Article 40, Article 69, it talks about the state recognizing the intellectual property rights of individuals and promoting and protecting them. And further than the Constitution, we even have the Universal Declaration of Human Rights at Article 27, which also talks about the author of a work having, as in it's their right to enjoy the moral rights and all other rights that appertain from their creations. So these are rights that are enshrined in the Constitution and in other other conventions. So they are rights that are basically meant to protect the author's interests and to ensure that they gain some economic value from the work that they did, from the creations that they made, and all that kind of thing. So basically it is just about helping and ensuring that the authors gain something. And their human rights, most people argue that, well, these are just entertainment issues, but as I've laid the foundation in the Constitution, we have it in the Constitution, we have it in the Universal Declaration of Human Rights. These are also human rights, and so they need to be respected by all.
Okay.
Yeah.
Well, that's proper. Liz Lenjo, even as you add upon what your colleague has just mentioned, I was interacting with a couple of youthful individuals, and one question that kept on popping up, and perhaps you can satisfy their curiosity. The question for determination, according to them, was with respect to these challenges, whether it's the Jerusalema or the Firirida, which seems to be coming up. Does the public performance of these particular songs violate the artist's copyright to the song? I hope that makes sense. Talk to us about it.
So I'd like to imagine and understand that public performance means performing it to the public.
Yeah.
Showing a display. Again, one of the rights that the author has is the right to make available and the right to display their work. So if it's in a personal space, it's a non-commercial setup, then it would qualify as, within the exceptions and limitations of copyright for private use. The minute you record it, again, changes the dynamics. So I think people need to be very clear. I'll give another example. You have a wedding, you have this list of songs that you love, you and your spouse, you're walking down the aisle, you play them. That's personal use. The minute you record this video and put it on YouTube, you change the dynamics, which means now in this instance, you have to talk to the various authors of these songs and ask them, is it okay? Do I need a license? How do I interact for this information or for this video to be online? I think people have noticed that when you put up work on YouTube or on Instagram, you get a copyright strike where you're told this work has been reported for copyright infringement. It means the author in this instance has restricted the use on that platform. So if you must use, then you have to directly speak to the author. In other instances, you find you put this work online, you have used someone else's music, you have used someone else's sort of work and created maybe another piece of work, what we call derivative works, and then it's not flagged for copyright. It's not been flagged for copyright, not because you have not infringed, but because the author has put mechanisms on the back end with these social media and these platforms to figure out how they will monetize and benefit on the other end. So it doesn't mean that it's free. It's just that they have been very proactive with that. The digital space is what we what we can say is a business platform. It's a revenue stream for authors. So for those who have realized how to use the digital space, they have realized the impact it has on reproduction and distribution of their works. They have ensured that they have had conversations with some of these platforms that they always enrich themselves and that they always get the benefit, the commercial benefit of the use of their works. Then they make it much easier for themselves. They figured out the math. And then there are those who decide, you know what, I do not want my work to be used and permission has to be sought. Okay. Faith just talked about moral rights, which comes with copyright. And the moral rights basically mean that the author has the right to object any distortion, any use of the works that implicate or have an impact on their reputation. So for example, a corporate that maybe is involved in human trafficking, for example, then they decide that they're going to use your song online and dance to it. At the end of the day, it will have an impact on your reputation as an author, right? Yes. So then you have that right to object it because of that. Someone, sort of changes your piece of work in a way that you do not feel is okay with you as well. It is a right that you have under moral rights that you can object. Okay. So I think, yeah.
Well, it's getting clearer by the minute. Faith Amatika, does copyright law apply in every circumstance, perhaps in news reporting or educational purposes? Talk to us about this.
Well, as Liz hinted at the beginning, I think she said that there are some exceptions and limitations to the use of copyright works. Mm-hmm. And so some of these exceptions and limitations include educational purposes, news reporting, and maybe parody, making fun of a song or something like that, to make people have some entertainment from it. So educational purposes, like, for example, if you use a song in a school setting to educate the learners on something, then that one is under the exceptions. And this one is well stipulated in Section 26 of the Copyright Act and also in the second schedule. There is a detailed a list of those uses that fall under the exceptions and limitations. News reporting is also one of them. So you may not really be in trouble as a media house if you use those works. But if you use the works as a media house, like you just play to entertain your listeners or your viewers, then of course that one is not part of news reporting. That one is a use as a broadcasting house, and for that you need to pay. So you need to get a license rather. So there are some of those exceptions. When we've talked about the educational purposes, news reporting, parody or making fun of such works, there's a whole list of that. So yes, there are some exceptions and limitations. Okay.
Now, still with you, Faith Amatika, as we reach a conclusion. Now, what happens to those institutions that might have uploaded, did the challenge, uploaded it on YouTube? Now, what happens when these masters come calling?
Well, they use the works. They use the works, and they have to pay up as per the invoices. They may negotiate or they may do whatever they want to do. But you see, as Liz hinted, it is they used the work. They promoted their brands, and it was they reproduced it in such a way that they shared it. They uploaded it on YouTube or on other social media platforms. So it was. They actually did what is usually exclusive to the copyright holder. So by doing that, they infringe the rights. So they will definitely just have to pay for what they did. But if it was just something they did at home in a private setting, then it will fall under the exception. So for that, they will have to honor the invoices once they are given to them.
Okay, Liz Lenjo, I have to be the advocate of the devil this time round. I mean, prejudice has been suffered by the author of the song, Master KG, but hasn't it been overridden by the fact that, I mean, he's definitely got good fortune from all the challenges. I mean, he's a global sensation right now. What say you about someone who might argue that way?
I think one thing people need to understand is that copyright lasts for the lifetime of the author plus 50 years in the Kenyan jurisdiction, in some countries plus 70 years. So his rights are still valid. With the diverse use of music, especially with the digital space, like in this instance, I presume, I'm not party to the facts on how, they have engaged Warner Music, but Warner Music in this instance, I believe is their publisher. And a publisher is usually that marketing entity that an author would engage and ask them to manage their rights, where they transfer their rights, and this particular publisher manages their rights and figures out how they have been exploiting their rights. Have they been doing the right thing? Are they aware of their copyright? And how do they monetize their copyright? That's the role of a publisher. So in this instance, Warner is just doing what ideally the author would have been doing themselves if they had the capacity. Warner has the capacity, and now they are, sort of ensuring that everything is as should be and that everything is following the law. At the end of the day, it's about being smart in the music business. It's about knowing your rights. When you know your rights, then you're better off. These challenges, as used currently, it means that they have that potential to spread the reach of the music, to further reproduce the music. So the author needs to realize this from the beginning and figure out and negotiate some of these avenues with the social media platforms, and be aware and walk 10 steps ahead to be able to control it, and even if they can even come up with rules on how some of these challenges can be done on the social media so that they benefit from the beginning. Then we avoid this misconception that this person has already had too much, why are they being greedy, or they've already achieved their purpose and things like that. I think it's very important that the authors and the artists in general are aware of this.
Okay, that's proper. Faith Amatika, as we conclude, seated at home, it's a digital space, definitely. I'm at liberty to share videos, especially with this Firirinda, which seems to be trending right now. So what advice would you give me before I choose to upload myself dancing to this particular song? What advice would you give me if I'm to, bear in mind the copyright laws?
Yeah, as I've said, uploading amounts to a use of the copyright work, which use is exclusive to the copyright holder. So if you record and you just use it for your own private use at home with your circle, your family members, then you may not, you'll be safe, so to speak. But if you want to go ahead and upload on YouTube, you dancing with your family, you might need to get permission, because that one amounts to a use which might land you in problems.
Quick question, does it just apply to YouTube?
No, not just YouTube. I just used YouTube because it's popular and it's what most people use. But whatever, even if you upload it on any other platform, Spotify or wherever, it still amounts to, an infringement if the permission is not sought, because as you do that, then the work is going to be accessed by the public, by people who are, globally. Anybody can access it when you do that. So you are reproducing that work, which is the preserve of the copyright holder or the author. So in that case, you might find yourself in problems if you do not get
that's interesting.
Yeah.
Liz Lenjo, perhaps give us your final take on this.
I think my final take would be for authors out there, owners of copyright. It's always important to educate yourself about your copyright rights. It's always important to know about intellectual property rights in general. and this helps you monetize and control your works better and benefit commercially from the works from an informed perspective, and then you don't need to play catch up with the law. Arm yourself with a team of lawyers or a lawyer who will advise you from the onset of creation. Do not wait to use a lawyer at the end of the process or when there's trouble, because again, legal services will become more expensive when someone is trying to play damage control or fight a fire. So I think it's important that they are aware of this fact.
Okay, that's proper. Faith Amatika, your take on this?
I think my final thoughts would be, just as Liz said, as an author, you may need to be aware of your rights. And some authors really are ignorant, and they really don't know. When, as you talked about the sensationalization that was brought about by Jerusalem, it became a worldwide sensation. And maybe an author might feel like, what's the problem? I'm becoming very popular, and it's really good for me. But you need to think about your own economic benefits. Are you getting anything out of other than just being popularized? So authors need to be aware, need to be on the lookout. They need to, as Liz said, they need to be aware of the law and know that they can get something out of their creations. And they should not just think that popularity is everything. Yes, it is good to be popular. It is good for everybody to know you. But if they know you and you are broke, then what is the point of it? So
if I'm an author and I want to make money, how do I ensure that my shilling is safe? Even we live in a world of social media, the digital space is enlarging day by day. How do I make sure?
Yeah, as Liz said, make sure you get yourself a lawyer who can advise you, and so that you can know how to make your work count, to make your popularity count, because as I said, it doesn't really make sense to be popular and broke. So make sure you get to know the law. You may not really understand everything, but at least arm yourself with a lawyer who can advise you as you enter into agreements. Yes, it might be popular, like in the case of Jerusalem, it was the president actually who said, he said the people should take up the Jerusalem challenge and, rally each other to support each other during the COVID times and, lift each other's spirits. But apart from that, what are the copyright issues that are involved in just rallying each other and supporting each other and making each other feel strong in the face of a pandemic? So there is more to it than just the fact that yes, it's popularity and it's it's a call to be strong. So there is more to it than that. So I think as opposed to just looking at one side of it, an author needs to look at both sides and consider, well, you might decide to waive your rights because it's also allowed. You may decide you don't want to enforce your copyright. It's also allowed. Yeah. But if you feel like that you really need to make money out of your creation, then it's good that you make the right decision from the very start. Make sure you have a lawyer who guides you. Make sure you have every T crossed and every I dotted, so that you don't come back later and start saying, I missed this opportunity and now it's gone, and then you sit there and you can't do anything about it.
All right, well said. I mean, ignorance is no defense, so don't turn a blind eye to the law and don't consider yourself not exploiting this particular song in case you're using it for especially commercial purposes. Many thanks. Faith Amatika, Senior Legal Counsel, the Kenya Copyrights Board, just helping us dot the I's and cross the T's, as she mentioned. Also joined by Liz Lenjo, who's an entertainment lawyer, joining us via way of Zoom from Kilifi County. Ladies, many thanks for your input right here. I'm pretty smarter right now. I won't post it. I wouldn't approach it that way. Many thanks. Let's take a short break right now. A lot more on the other side. We'll be shifting focus to the world of sports in just a few. Stay with us.